First of all, just an introduction of me for those of you that might not know who I am. My name is Bhavik Patel. I am an estate planning attorney and a special needs planning expert in this region. I think I've given over 100 or so of these presentations to ARC family. So really appreciate being here and thanks for listening in. I do want to talk about something that's not so public benefit related, but I talk about this in all 100 or 200 presentations I've given. And it's very, very important because what I want to talk to you about is the ways that inadvertently end up locking the door. So I want you to be aware of common pitfalls that families are doing all the time. And I guarantee you, the vast majority of people listening to me, one of these pitfalls is going to apply to you. And I want you to hear it. And then I want you to solve it so you do not walk down the inevitable path of having that door locked. The first of these ways is 529 plans, transfers to minor acts accounts, or custodian accounts. Those accounts could potentially lead to locking the door for Joey in the event that you have any of those accounts or that those accounts rise above the threshold. Unstructured beneficiary designations. So I used to give this presentation live at the wonderful ARC facility where I'd make everybody go through this exercise where they raise their hand if a scenario applies to them, and everybody's hands would go up. And then I'd have to tell them anyone's hands that are up is running into a common pitfall. So I won't go through the fun exercise because we're virtual and I can't see you, but I will highlight what I'm talking about here. Some of you have life insurance. Some of you have 401ks, IRAs. A lot of you have some of those things through your employer, which you started working. When you're working, you went to the orientation or onboarding. They told you about the 401k or the employer life insurance provided or whatever. They make you fill out all these forms, and then you put on the beneficiary designation, my spouse, if you are married, and then underneath it as the contingent beneficiaries, oftentimes people put my children. Well, that's a problem because depending on when people die, that beneficiary payment could end up going to Joey. If that ends up going to Joey and it's above the threshold amount, you just lock the door. If you have life insurance outside of your employer, same thing. Read the beneficiary designation. What did you put on that beneficiary designation? The solution is, let's say I have Emily and Joey as my two children. And let's say I'm the audience here and I put my wife, and then I put, after my wife dies, I wanted to go 50-50 to Emily and Joey. Well, that's a problem because of why I just said. All of a sudden that money goes to Joey. Boom, disqualification or locked door. Instead, the solution requires that I should write 50% to Emily, and then I should write 50% to the special needs trust for Joey. Now you got to go create a special needs trust. Almost anyone that wants public benefit eligibility for Joey is going to need a special needs trust in some fashion. I'm not going to talk about special needs trust. There's many different types. There's some that are very affordable, that are done through almost quasi-governmental organizations. And then there's the more private-based ones that are much more customized to meet your needs, that are law firm drafted or lawyer drafted based. And then there's different types of special needs trust, which we won't get into. My point in saying that is really that's the solution. That's how you're going to avoid that door from being locked. The third one is directing funds to be held informally by another family member. So that I could put 100% to Emily, and I just know in my heart of hearts that Emily is going to take care of Joey. And maybe that's true. Maybe that is what Emily is going to do. I don't know if anybody can guarantee it, but maybe it is true. And Emily's a sweetheart and she loves her younger brother, Joey. And so she is going to do that. But what happens if Emily gets married and then maybe gets divorced? Or what happens if Emily gets in an accident and is in a lawsuit? What happens if Emily has children of her own and has financial hardships and now is torn with using some of that money for her own children instead of Joey? Or what happens if Emily's in financial problems and she has to file for bankruptcy? Here are all things where Emily loves Joey and wants to take care of Joey, but you have created vulnerability to the amount of money you left Emily that was supposed to be informally held for Joey. I am very adamant. Disinheriting Joey is the worst kind of planning you could do. I think it's just I obviously I'm very opinionated about this. I think it's absolutely almost disgusting if I have to use a very harsh word. At least I want you to think like that now that you know why. Maybe you did it originally because you just thought, hey, I don't want to lose Joey's benefits. You're much better off leaving Joey's inheritance or beneficiary designation money to a special needs trust and naming Emily to be in charge of the special needs trust for Joey. At least that way, what could go wrong in Emily's life won't impact what would happen to that money that was carved out for Joey's care. Gifts from non-parents is another pitfall. Grandma, grandpa is going to leave Joey some money through their own estate planning, or they just want to leave a gift. They don't think about it. They just say, hey, everything, $100,000 is going to go to Joey, and that's what they write down in their will or their trust or their estate planning documents. And then grandma and grandpa die. I mean, they had a wonderful heart to want to take care of Joey, but a really terrible consequence because they just locked the door to the benefits. So now that $100,000 is getting churned and spent for things that the government was already paying. So gifts from non-parents. Now, what's the solution there? Honestly, I think the solution there is that you have to have proactive conversations with your non-parent family members. You need to just ask them, hey, are you planning on leaving Joey money? A lot of them will say, no, I'm going to leave it to you. And then when you die, it'll go to Joey. Well, what happens if you die first? Then it would go to Joey. So there's, the conversation is very important. And if you find out some other family member does desire to leave Joey money, that's a good thing. And if you do find that out, you're going to need to create a special needs trust that is already available and ready to receive that money when it comes. And then you need to tell that family member to modify their documents to say whatever goes to Joey needs to go into that particular special needs trust. And then that will solve the problem. That will eliminate that door from being locked. The last one is moms and dads that are on the call. If you yourself do not have your own estate plan that says where things go, you're going to run into a problem. If you do not have that kind of plan in place, the state of wherever you reside has written a will for you. And that will says, when I die, half of my assets go to my surviving spouse if I have one, And the other half or all of my assets, if I don't have a surviving spouse, will eventually go to my children, Emily and Joey. We have that same uh-oh moment because now Joey received assets and the door is locked. So these are things I see happening all the time that's walking people down the inevitable path of disqualification of public benefits. I want you to know which ones apply to you, and I want you to tackle those issues so you don't have an inadvertent disruption of benefits.